Okay, people, everybody, good morning. Welcome to the webinar that we're hosting today. It's great to have you all here. This webinar will be recorded. So if you need a recording afterwards, just let me know and I can email it to you. What happens afterwards, we just edit it. We edit it first and then we will forward to you if you're interested in that. Just one or two house rules. Please at all times mute yourself, and then you will see there's a chat box. If you do have questions, ask the questions in the chat box, which Saloch will answer afterwards. And after we've answered the questions in the chat box, we will also give you an opportunity to ask questions. All right, I'm going to share the screen. What we've got today. So today we're going to discuss the practical implications, what happens in your estate after death, but before the executor is appointed. Our presenter is Salochana Packery, as we know her as, or we know her as Saloch. Saloch is admitted attorney. She's also soon to be admitted a notary. She passed the exam a few months ago. She's done the lead course through UNISA, the Law Society Certificate of Deceased Estates Administration, and she's got more than 14 years experience in specialized deceased estates administration. Saloch used to work in the corporate environment. She joined us a few years ago, and she's now the head of our deceased department, and also which includes the wills department. Saloch leads, manages, and develops staff internally and processes to achieve the highest possible standard of service delivery. Her role also involves the personal interaction with clients, at which time various aspects of the estate administration process are discussed. Saloch, thank you. We're all looking forward to what you're going to share with us, and I'm handing it over to you now. And yeah, Saloch, all yours.
Thank you, Jan. Thanks for the introduction. Good morning, ladies and gentlemen, and welcome to our Deceased Estates webinar. I trust that you will find this a very enlightening and informative session. Now, deceased estates and death in itself is a very sensitive subject, and usually after the funeral takes place, people are at a loss of what to do next. In my exposure in the industry, I've encountered extremes of emotional highs with family members reacting to the loss of their loved one, ranging to them expressing great bitterness towards the deceased for leaving them in an unfavorable position, and then to those family members who have openly feuded during our consultations. Now, everyone has an opinion about what someone had either shared with them about deceased estates or what attorney Google has provided by way of advice on how an estate should be administered. However, what predominantly remains the same is there's a general misunderstanding of what happens in the winding up process of a deceased estate. Today, I would like to share with you the most commonly asked questions and hope to provide some practical steps that can be taken and that we should consider when consulting with clients or advising loved ones when someone has passed on. So our first subject that I'd like to talk about is actually what we commonly asked and approached to do is, can I access funds from the deceased bank account? Now, normally when someone passes on, the first thing that the family members would do is start with the preparations of arranging for a funeral, to perform the last rites for a dignified send-off. Now, usually if the deceased did not have a funeral policy to cover these expenses, it leaves the family at a loss for funds, and they usually would get together and try and come up with the funds to actually have the funeral. But as we all know, funerals can be quite expensive. These days, your cheapest funeral costs around 20,000 Rand. And we are often approached by family who come to us, usually after they've already gone to the bank, to ask us, we don't know what to do next. The deceased bank account is frozen. How do we access funds? So technically speaking, the deceased bank account becomes frozen when the death certificate is presented at the bank. So the bank rightfully would note that the account holder has passed on and makes a note on the system that no one else can have access to that specific account. The executor will be the only authorized person to close the bank account once the letter of executorship has been issued. The bank will also not authorize any access to those funds from the deceased bank account from any party, including the spouse as well. And the most important solution here is if funds are needed to provide beforehand by way of a funeral policy. Now, sometimes it is also that we'll find circumstances where the spouse or close family members would come to us and say, you know, someone has told me that it's fine for me to move money from my husband's account. Now, technically, this should not be allowed because it has great repercussions in the estate process if funds are moved prematurely. What usually happens is there's a ripple effect which results in a cash shortfall in the estate, which obviously allows the progress or hinders the progress in finalizing the estate. Also, the local bank does not have the authority to close the bank account of the deceased. And this instruction is carried over to the bank's deceased estate department, where the bank will follow internal protocols not to release funds to any other party except to the executor who has provided proof of an estate bank account, and where the executor himself will undergo strict FICA verifications. But we do obviously have the situation sometimes where you have a surviving spouse and the surviving spouse was solely dependent on the deceased and is at a loss for funds. Now, in those circumstances, what we do recommend is for the spouse to have a consultation with the executor or soon to be appointed executor, where quick cash analysis can be done or cash assessment of the estate can be made. And if the spouse does have access by way of an ATM PIN or a internet banking, that some funds with the executor's consent and knowledge can be moved to provide for the spouse to actually maintain herself for a couple of months until there is some liquidity in the estate. Obviously, the other possible solution would be to have a separate account, a separate bank account where the surviving spouse could have access to and would be able to maintain herself or himself for the duration of the admin process. Something else that I'd like to discuss with you, and that's on our next slide, would be a concept of, one further, Jan, thanks, would be the concept of solvency versus liquidity in an estate. So one is to understand the concept of solvency, and that specifically pertains to your assets exceeding your liabilities. Or in an instance where your assets do not exceed your liabilities and your liabilities are much more, you are looking and facing an insolvent estate. So with the simple example of, if you have an estate with an asset value and assets consisting of a property of R1 million, a vehicle of 100,000, a bank account of around 80,000, amounting to a total asset value of 1.180 million, and liabilities which include perhaps a bond, vehicle repayments, a personal loan, credit card, and those liabilities amount to 1.4 million, you could see that your liabilities exceeds your assets value and therefore resulting in an insolvent estate. And that pertains to, is your estate solvent or insolvent, versus the concept of liquidity. Liquidity pertains to having cash in your estate to pay all your liabilities. So in a similar instance, if you were to have an asset value of 1.2 million, but only 20,000 in the bank account of the deceased, and you'd have liabilities of 80,000, one would understand that there is value in the assets, but there's no liquidity, there's no cash to actually administer the estate and pay for the liabilities. Hence, bringing us to our next topic, which would be, can assets be sold from an estate, and at what point can assets be sold? So one would have to look at them individually, and I've sectioned them off into what is most predominant in most estates. We'd look at property first of all, and the question is, when can property be sold? Now, property, if the intention of the beneficiary is to sell the property from the estate, or if a will expressly compels the executor to dispose of the property, the executor only has the authority to enter into this legally binding agreement of sale once the letter of executorship has been issued. Therefore, for all practical reasons, the property should be safeguarded, especially if unoccupied. A property agent can be enlisted or contacted in the interim to provide a preliminary valuation of the property. The property agent can be contacted to market the property with full disclosure that certain steps need to be followed before the sale can be concluded, and the prospective buyer needs to be made aware of these provisions. Firstly, the executor being successfully appointed by the Master of the High Court to enter into such a sale agreement. Secondly, the sale in a deceased estate is subject to the approval or endorsement by the Master of the High Court. And thirdly, the sale is subject to the written consent by all relevant beneficiaries. Now, one must remember that if a property is bonded, the bond will expect monthly repayments. So it's important to try and maintain those monthly repayments. Now, sometimes we approach by clients saying that, you know, they were told that it's part of an estate, they don't need to bother anymore about payments, but unfortunately this is untrue. Remember that property still belongs to the bank, and until settled in full, either by way of proceeds from the estate or by credit life policy, it remains a liability to the estate and not really property of the deceased estate as such.
Did you put me on mute?
A common question that we are also asked is, who needs to pay for the monthly maintenance and upkeep of property in a deceased estate? Now, the quick answer to this would be the person residing on the property has to pay for utilities, with the owner ultimately responsible for rates on the property. That means that rates and taxes clearances will be settled from the estate at the appropriate time in the administration process, bearing in mind that any arrears will have to be paid when the final rates is settled. Now, the situation may be in an estate where no one's actually residing on the property. Beneficiaries have their own properties that they live in, but it remains a concern and as a risk of the asset before transfer can take place. And all of these utilities still need to be paid. So with consultation and collaboration with all beneficiaries, the suggestion is that one specific beneficiary could make payments of the monthly upkeep and maintenance of the property, and they could potentially be reimbursed by the estate at a later stage once there is liquidity in the estate. The second asset that we are always approached is regarding vehicles, the sale of vehicles. Now remember, a vehicle, unlike a property, cannot be transferred to more than one person. So one has to carefully consider if there's multiple beneficiaries in an estate, Who's going to get that vehicle? Who would it be transferred to? Is it specified in terms of the will? Or, you know, are the beneficiaries going to come to an agreement in terms of who will take ultimate possession of that vehicle? The body of authority that facilitates the transfer of vehicles is the traffic department. The executor is the only person who is able to sign the notification of change of ownership forms on behalf of the deceased. Hence, this can only take place once the executor is officially appointed. If the intention of the beneficiary is to sell the vehicle directly from the estate, or if there's a need to sell the vehicle from the estate, this has to be subject to the executor first being appointed. Another challenge encountered during the estate process concerns expired licenses. Now, sometimes we approached and we're already told that licenses have expired. How do I drive this vehicle? And at an early stage in the process, one cannot give transfer of a vehicle. So what the executor can do once he is appointed is provide a letter to the beneficiary, who can go to the licensing department and request a renewal of the license. It's important to note that expired licenses or arrears licenses are an estate expense. It's also very important to note that with vehicles still, that it's important to insure the vehicles to mitigate risk until transfer can take place. Also very important to note, if the vehicle has finance or is under finance with the financial institution, and there's no credit life cover to settle that vehicle upon the death of the owner, then one needs to remember that that financial institution is the title holder and retains the right of possession of that vehicle. And with vehicles specifically, the financial institution would contact the clients quite quickly as opposed to a property, and would want to come and repossess the vehicle, taking the vehicle into their possession. One has to remember, when the vehicle is repossessed, it gets stored. The estate is then liable for storage costs. The vehicle is then sold in a sale and execution or auction, and the vehicle can potentially be sold for a lesser amount in terms of what is outstanding. And thereafter, the estate can still be held liable for any deficit on that account. So very important to know, don't readily release the vehicle without consulting the executor first, where the executor can potentially buy a couple of months, where one could look for a private buyer, where you could sell the vehicle privately in an effort to either obtain a profit on that vehicle or to settle that debt in its entirety. Something else that is a huge pain for the executor during the administration process and becomes a very sore point are firearms. Now, firearms carry a huge risk for the appointed executor in his personal capacity, which could include a jail sentence of up to 20 years. Now, if a will dictates what should happen to a specific firearm, it should be borne in mind that that specific beneficiary inheriting a specific firearm does not have a license for that firearm as yet, and still needs to undergo the process of applying for a license and passing his competency test to possess that firearm. Therefore, for practical reasons, when dealing with firearms, the best would be to ensure that they are held in safekeeping. And only the appointed executor can sign the necessary South African Police Services forms to ensure that the firearms are transferred to the respective beneficiary or purchaser, or held in safekeeping by a registered firearm dealer. Only with the executor's consent can firearms be stored, and a permission to store firearms can be provided by the executor, whilst the beneficiary may be undergoing a competency test and his application to possess such firearm. Now, many would know that during the amnesty period provided in years gone by, there was an opportunity to hand over firearms to the South African police services, and many people had taken advantage of this opportunity. But important to note with the deceased estate specifically, when handing in the firearm, either for destruction to SAPS or to any other dealer, to obtain a written receipt that such firearm has in fact been handed over. At the end of the estate process, one would look for transfer out of the deceased name into a respective beneficiary's name, or proof of destruction as your ultimate proof that the firearm has been dealt with. Obviously, the safer option is to have it stored with a registered firearm dealer, have it dealer stocked until the firearm can actually be transferred. And it's important to note that storage fees are payable. So once again, the process of firearms can only take place once an executor has officially been appointed to enable him to sign the necessary SAPS forms. When it comes to movables, now when I refer to movables, I'm specifically referring to furniture and household effects of the deceased. And we often approach with the questions of, you know, we either don't have much value to the movable items, they're very old, they're more of a sentimental value, or we approach and we'd say, you know, my dad resided at a retirement unit. I have until the end of the week to remove the contents of that unit. Can I start selling these items? Or we'd be asked, in terms of the world, specific items were bequeathed to specific people. Can I start handing these out? Or the other concern would be, people are coming into my dad's house, they're starting to remove items, what should I do? Now, it's the executor's duty to take under his care and, if necessary, into his possession the assets of the deceased. It's important to note that when one specifies itemized items in a will, that an itemized valuation needs to be conducted. So, for example, if I left my Carol Boys dinner set to Sarah, my Empasol sewing machine to Anne, and the family kissed to Jack, then every item that I've specifically mentioned needs to be allocated a value, which is required for estate purposes. Now remember, to appoint a value or an appraiser means that additional costs would have to be incurred in the estate. But when it comes to specific items such as Krugerrand coins, a stamp collection or artwork, then absolutely an expert appraiser needs to be approached for a more accurate valuation. It's also important to note that when items are removed from premises, that specific beneficiary provides you with a written acknowledgement of receipt, confirming to the executor that they are now in possession of the item that was bequeathed to them. If the executor also permits a beneficiary or to sell or dispose of the item during the estate process, then those funds are payable to the estate bank account. Very important also to note is that concerning minor children in an estate who may be beneficiaries, then it's absolutely a requirement to provide a sworn appraisal of the movables and immovable items that has to be provided to the Master of the High Court. So the long and the short regarding movables, can I remove items? The idea is, or the advice would be no, unless it's practically impossible to keep them on the deceased premises, or it is a risk to keep them on the deceased premises. But if they need to be moved, they need to be moved with the executor's consent and full acknowledgement of receipt of a specific item, and with a value awarded to that specific item removed. What we are often approached with as well, or asked during the process is, or early stages is, can I sign a rental agreement? My dad's house was left to me and I am ultimately going to be the beneficiary or owner of that property. I have my own property that I'm staying in. Can I rent this house in the interim whilst it is vacant? Now, one must remember that the appointed executor is the only person who has the authority to enter into a rental agreement. Usually the executor would steer away from such agreement unless it is absolutely necessary and within the best interest of the estate and the beneficiaries to enter into such a lease. It is also not advisable to enter into a long-term lease, and the executor may choose for several reasons to enter into a shorter lease agreement. And some of these reasons would be to safeguard the property if it's unoccupied, or to ensure that there's a bit of liquidity to maintain the monthly utilities where there is a cashless situation. But one needs to carefully consider and understand the risks involved with entering into a premature lease agreement. And risks entail, the condition of the property that the tenant potentially could hinder. Secondly, the fact that the tenant could default in payments, or if there's a potential buyer a few months on to the property and the tenant does not want to vacate. All potential legal issues that becomes the responsibility of the executor, ultimately resulting in the executor taking legal steps to get the tenant evicted from that property. Also, the granting a rental agreement gives the tenant a very strong legal right. So if we were to enter into a 6-month lease or 1-year lease with a potential tenant, and 4 months down the line, one obtains an offer to purchase on the property, remember that that tenant has a very strong right in terms of seeing that lease agreement through before the property can actually be sold, or the new owner can receive vacant occupation of that property. So very important to consider when one wants to enter into a rental agreement. However, important to note, it can only be done once the executor is officially appointed. Now, funeral policies, one asks, or I started off the webinar talking about funeral cover and access to the bank accounts. And what I did recommend was to have funeral policies in place, ideally to cover funeral expenses. Now, funeral policies are usually held with a funeral undertaker, an insurance company, or it forms part of a final expenses benefit on a life policy. Funeral policies usually pay out within 48 hours and only a death certificate is required. However, in certain circumstances, a letter of executorship as well as proof of estate banking details will be required. And in some cases, it's usually when a funeral benefit is linked to a savings account that you may have opened up at a local bank, or in the instance where there's no nominated beneficiary to that funeral policy. That's when the letter of executorship only is required. And this claim it can be handled independently from the estate process, and one does not necessarily, in normal circumstances, have to wait for the letter of executorship. The other type of policies that obviously affect deceased estates are life policies. And life policies usually take a longer period to pay out, as the insurance companies need to follow certain internal protocols at claim stage. Now, life policies, if there's a nominated beneficiary, does not form part of the estate and can be handled separately and independently from the estate process. Usually, claim forms need to be completed, a death certificate provided, and a PMA, which is a personal medical attendance report, is required by the deceased doctor, disclosing the deceased medical history and cause of death. Only on successful admission of the claim will the insurance policy pay out the proceeds to the nominated beneficiary. What's very important, and I'm sure many people are aware of this, and you would have received advice from your financial advisor, is to review your life policy beneficiary on an annual basis. leaving somebody on as a beneficiary who is subsequently passed on is obviously a crucial mistake when it comes to life policies. Something else that we consider during the estate process and often asked about is the risk involved with assets during the estate process. And that takes us to short-term insurance over our assets. Now, one needs to understand that when the deceased bank account is closed, all debit orders that were running off that account are going to lapse if no alternate arrangements are going to be put in place. So before fixed property or vehicle can be transferred into a nominated beneficiary's name, the asset remains a risk in the estate. The estate bank account cannot facilitate debit orders, and usually in the inception stages, no funds are available until the deceased bank accounts are closed, provided there's funds available there. Therefore, it's advisable that the beneficiary arranges for immediate insurance cover over those assets. And usually a beneficiary is able to arrange for insurance cover over their assets, although it's not yet on their name, with their existing insurance provider, and they can facilitate the debit orders from their personal bank account. It's very important to mitigate that risk and avoid any potential damage to, or if there was any potential damage to those items, that there would be cover in place. Something else to understand are credit life policies on debt incurred with the financial institution. Now, credit life policy is different from your short-term insurance policies, different from your life policies, and credit life policies would be secured or ceded to specific debt that you may have incurred. So for example, on a bond, on a personal loan, on a credit card, or on vehicle finance. But one needs to remember that credit life insurance is optional in most instances and holds an additional installment that is an add-on to all of this debt that when you're incurring these, the bond or personal loan, etc. And there's also various factors to take into account that could affect the credit life insurance, such as age, which would disqualify you from taking out the life cover. There could also be restrictions on life cover, such as if there are medical exclusions or pre-existing conditions. There's also time frames or time limits on policies paying out, and that would be in an instance where there may be a 2-year waiting period for suicide. And these all need to be considered very carefully. And most people, when we discuss estates with them and discuss the debt in the estates, for example, a bond that does not have credit life protection, clients tend to get very angry with us, but they don't understand the foundational reasons for not having cover in place. And it could very well be a simple thing such as the person refusing to take out cover or providing proof of life cover somewhere else, but during the course of his lifetime, that life cover may have subsequently lapsed, resulting in no cover over the bond at the time of death. Now, until a claim is settled either from estate funds or proceeds of credit life insurance, it remains a claim against the estate, and interest will continue to accrue until it is settled in full. Credit life insurance, as I mentioned, is an add-on, and it's an additional optional installment and is very expensive, and people cannot usually afford it. In these tough economic times, people cannot afford anything extra. And in most instances, when it comes to credit life insurance, the only thing that may be required is a death certificate. Sometimes a PMA report, the personal medical attendance report, is required, and in rare instances, the letter of executorship may also be required. It is advisable that even if one is aware that there's credit life insurance over a bond, to still try and maintain those monthly bond repayments. Any credit life that pays out on a bond, for example, any credit that remains on that bond will be reimbursed to the estate. Now, as you may have come to realize, the true administration process of an estate can only in most instances begin once the executor is officially appointed. However, there are some instances where you can take immediate action, and that is in the instances of debit orders that have been running off on the deceased account. Remember, I mentioned that once the deceased account is closed, those debit orders will cease and potentially they would lapse. So one needs to ensure the continuity of those debit orders by making contact with the service providers and providing new banking details. Such service providers could be short-term insurance, could be armed response. And in the instance with medical aid, it's very important to ensure that there's no break in cover for a surviving spouse. So one needs to ensure that new banking details are provided to the medical aid as soon as possible, and the surviving spouse who may have been a member on that medical aid now has to be switched to being the principal member. Something else where you can take immediate action is when it concerns final salary or leave pay, where the surviving spouse can make contact with the HR department of a specific employer. And in most instances, the employer may pay that final salary to the surviving spouses. However, they may also have a restriction on that payment and want the estate banking details and the letter of executorship, and only be obliged to pay to the estate at a later stage. Something else that one could attend to almost immediately is retirement annuities and pension funds. Now, when it comes to pension funds, one needs to remember that a pension fund or retirement annuity is governed by the Pension Funds Act. And the claim is handled independently from the estate. So you can begin almost immediately with a death certificate and with the necessary forms provided by the insurance company, and start with the pension fund claim as such. Something else would be UIF claims. You have up to 6 months from date of death to claim UIF, which can be done by the surviving spouse at the Department of Labor. A very important subject that comes up is businesses, and often we approached and asked, what do we do with businesses? It's a going concern. We need to carry on the business entity. We can't stop and wait for a letter of executorship or for the estate to be wound up. Now, it's very important to note that the executor has the authority to step into the deceased's shoes and act in the capacity as director. But it's not always practical for the executor to do that. In an instance where the deceased may have had a logistics company in KZN or a bed and breakfast in Cape Town, or an engineering plant in the south of Johannesburg, it's impractical for the executor, who may not have personal knowledge of running that entity, to personally get involved and have it continue as a going concern. Therefore, the executor may decide to appoint a beneficiary to manage and run the day-to-day affairs of the entity, such as daily operations, purchases of material, staff wages, etc. One is to also beforehand have these discussions with the testator in terms of the practicality of bequeathing a business entity to a family member. One needs to ask, would this family member be the ideal candidate to carry on business? And that's where succession planning becomes very important. Understanding the importance of having the financials up to date is also imperative. Now, a business is a separate legal entity to an estate, and whilst the business entity can, in essence, continue running as a going concern, there are certain formalities that one needs and certain information that one requires for estate purposes. And that would be, with the financials being up to date, one would need a valuation of the member's interest or the shareholding of the deceased as at date of death, as well as any loan accounts in the deceased's favor as at date of death. And therefore, it's imperative to have financials up to date in order to provide the information. Any transfer of shareholding or interim change of directorship can only be authorized and signed once the executor has been officially appointed, and usually the auditor or accountant attends to that process. Therefore, it's very important to allow for business continuity, to look at shareholders' agreements that need to be in place, or buy and sell agreements, or allowing authority to partners or surviving spouse to have access to business accounts during the lifetime of the specific person, so that there can be continuity at a later stage. When it comes to investment portfolios in a deceased estate, one has to look at the options available and presented to the beneficiaries. Now, in most instances, one has the only option to redeem or to disinvest a portfolio. But in some instances, you do have the option to transfer a portfolio. And some of the advantages of transferring is that where there's a beneficiary who has an existing portfolio, we could facilitate the transfer into that existing portfolio, saving potentially on capital gains tax and avoiding early redemption penalties. Whereas opposed to redemption or disinvesting a portfolio, one is going to look at capital gains tax and early redemption penalties. Now, depending on who your executor is and who your agent is to administer the estate, a financial advisor can have a very informed discussion with the administrators of the estate, the executor of the estate, to discuss cash flow and liquidity and decide about disinvestment or transfer. And if there is a cash shortfall situation in an estate, the decision can be made to actually transfer part of the investment and disinvest part to provide for liquidity in the estate. However, disinvestment or transfer can only be facilitated once the executor is officially appointed, as a letter of executorship is required, and the executor is required to complete and sign the necessary transfer documents or redemption documentation. Shares, something else, another asset in the estate where one has to consider, can I redeem, can I sell, can I transfer? And once again, when it concerns shares, one can only give formal instruction to the administrators of the shares once a letter of executorship has been issued and the executor is in a position to actually sign the relevant documentation. Ladies and gentlemen, we are almost towards the end of the webinar, and I'd just like to touch on something very important, and that is the importance of a life file. Now, when I consult with clients, when they're drafting their wills, I usually ask them, how would your family know that you have a will with us when you pass on? And how would your family know what assets and liabilities you potentially have in your estate? Now, the reality is that people are very private about their personal lives, let alone sharing details of their assets and liabilities with other family members. And for that specific reason, a life file is so important. A life file is just a flip file, if you call it, in whatever manner you want to hold it. And it provides valuable information of where your will is kept, who your appointed executor is. It keeps a copy of the will there. One could hold a list of assets and liabilities that no one else would be privy to until the point when you do pass on. It also contains or can contain special instructions personal instructions in terms of funeral arrangements when you do pass on. Important documents or copies thereof, such as the title deed, your marriage certificate, the divorce decree, antenuptial agreement, all very important documents required for the estate process, can be kept and maintained in a live file. So that is something that we would like to promote, a live file, very important to advise your clients accordingly, and for yourself as well in future to have this, which is of utmost importance. Ladies and gentlemen, that brings me to the end of our webinar. I hope that it's been informative and has provided some practical steps, or has at least got you thinking about certain things. I'm going to hand over to Jan now, who will go through the chat box, and we will attend to your questions shortly. Thank you.
Thank you, Shalosh. Awesome. Before I look at the chat box, maybe one or two questions for myself. From a practical point of view, if somebody passes on and I'm not an heir, but I'm prepared to, let's say, pay the funeral costs, or I am an heir and I'm prepared to pay the maintenance of the house, maybe pay people the help at the house, etc. Can I claim the money back from the estate?
Yes, definitely, Jan. Once again, provided there's liquidity in the estate to claim, to reimburse you, there are definite estate expenses as set out in the Act. Funeral costs are one of those expenses that can be reimbursed early on in the process, as soon as there's liquidity. So in answer to your question, definitely, if you are actually paying for these expenses, then you can be reimbursed. Maintenance of the property and so forth would be an estate expense ordinarily, and if you are willing to pay that, then you can be reimbursed from the estate. Okay, then I've got a bond over my property, or the deceased had a bond over his property, and we inform the bank. Will they immediately take steps to repossess the house? Or does the banks, or do the banks understand the whole concept of deceased estates, and it takes time? And maybe just touch on the estate department and for the banks. The banks definitely understand the concept of a deceased estate. In essence, the banks would be able to grant the executor or the estate a 6-month, potentially a 6-month leeway, provided one keeps the channels of communication open with the bank. So every bank has your deceased estate department that handles where it goes to legal, where it now is a deceased estate matter. So at the end of the day, one would communicate, the executor would communicate with that specific department, and we'd keep the channels open in terms of informing them. The intention of the beneficiaries, for example, is to sell, but we don't have a purchaser at the moment, or the spouse is coming into some funds, we hope to settle soon. Keeping those channels open is of utmost importance. But at most, one is going to get a 4 to 6 month leeway by the bank to actually, before they actually step in and take legal steps. But at some point, they're going to come to you and say, okay, you said you're going to do A, B, and C, what now? And then they may decide to proceed with legal action.
Okay. Thank you. Then another practical question. In the will, it states that Joe Soap must inherit my car. I pass on. Can Joe Soap come and fetch the car? And if he, before the executor is even appointed, and if he does, and he uses the car and is involved in a car accident, what are the consequences there?
It's not the ideal situation to release the vehicle to that nominated beneficiary. As I mentioned previously, the executor remains responsible for the specific asset, and it's the executor's responsibility to take into his control and even in his possession an asset until transfer can be effected. But sometimes the need may arise. For example, the beneficiary may be residing in Cape Town. He's here for the funeral in Gauteng, wants to take the vehicle with him. But the legalities of that is the vehicle is not yet on his name. It potentially is unlicensed. It potentially does not have insurance on that. In rare instances, the executor may agree to the beneficiary taking the vehicle back to Cape Town with him if the beneficiary is willing to indemnify the estate and the executor of any loss and damage caused to that vehicle, number one. Number two, if that beneficiary can prove that he has arranged for insurance over the item.
Okay, great. Let's have a look at the few questions that we received from Haneli. How do valuers for a property in the estate calculate the fee for the valuation? Is the percentage of the value of the property?
Hanley, I don't know the exact percentage, but yes, it's definitely worked out on a percentage of the property.
Okay, then there's a personal question. Is this presentation recorded? Yes, it is. And if you want a copy, just SMS or WhatsApp or email me and I'll send it to you. Obviously needs to be edited first. Then we had a question from Diane. What is a credit life cover?
So the credit life protection is when one, for example, if you have a, if you take out vehicle, if you buy a vehicle, when you are completing your application for vehicle finance, there is an option or a question that you asked. Do you want credit life protection? So credit life protection, as I mentioned, is an add-on or an additional installment to your monthly repayment of the vehicle, where one would say that if you should pass, then the outstanding balance on that account would be settled by the credit life protection policy. So that's in essence what credit life protection is.
Thank you. Shalosh, if an heir withdraws money or move money, transfer money after death, but before the executor is appointed, and it turns out that the deceased is actually insolvent or that he's got another will, what happens to that money that was withdrawn if that happens?
Rightfully, that, as I mentioned, this should not be done. It's actually seen and deemed to be illegal. So rightfully, that fund should be paid back.
Yes, thank you. Frank, my father-in-law provided his life policy as surety for an overdraft at FNB. FNB are the executors and they have finally asked for and received the funds. Can the beneficiary now receive the balance of these funds?
Absolutely. In an instance where a life policy has been ceded for a debt and the debt has subsequently been covered or part of the policy proceeds used to cover the debt, the remaining balance is definitely due to the nominated beneficiary. So yes, they can receive the remaining proceeds.
Hans asked, how long does it take to obtain a letter of executorship?
Hans, that's a loaded question. How long is a piece of string? So at the end of the day, the current waiting period is around 3 to 4 weeks with the Master of the High Court. That is Johannesburg specifically, but it varies all the time. So we're really at the mercy of the Master's office.
Okay. Johan Creer is making a statement. He says the balance should be available to pay out. That's from a life policy. If there are beneficiaries listed on the policy, it will go to them. If not, it will go into the state. Exactly that, Johan. That is 100% correct. Gloria, if you're married in community of property, does the living spouse's bank accounts also become frozen?
If you are married in community of property, that estate is deemed to be a joint estate. So what that simply means is that both assets and liabilities of both spouses are taken into account for the estate process. However, one does not close or freeze the surviving spouse's bank accounts. That remains open and they would have access to that. But the balances as at date of death are used for estate purposes.
Thank you. Here's another question. Is it true that if one's will is kept at the bank, then the bank automatically becomes the executor after the account owner passes away?
If a will is kept at the bank,
is it automatically, does the bank automatically becomes the executor? No, it depends on who the deceased.
Yeah, it depends on who's nominated in the will. You know, at the end of the day, usually if your will is with the bank, then you can count on it that the bank is the executor, because they wouldn't necessarily, 99% of the time they are the nominated executors.
Thank you. Then Nelson, you're asking me, can we please send a copy of the slides? You need to let me know what your email address is, and then I can do that for you. Jade, is it standard to wait 12 months from date of death for a person, for a pension fund to be paid to beneficiaries when the beneficiary is established? What's your experience, Charlotte?
It's not out of the ordinary. Once again, this is a process that falls out of the estate, out of our space. And really this process is actually governed by the trustees of a specific pension fund. Now, one needs to remember what the trustees are considering. They may look at nominated beneficiaries, but that is used as a motivating factor only. The trustees have to conduct their own due diligence in terms of who may potentially have been financially dependent on the deceased. And that's potentially the reason why it takes up to 12 months before a pension fund can pay out.
Then Nicholas is asking, if a property is left unoccupied for some time, how does one find someone related to the owner of the property? Nicholas, I'm sure that's an estate agent question. Maybe Charlotte just touch on the point of that you can actually go into the website of the master to see who the executor is.
Yeah, obviously, well, you'd start with a deed search of the property and look at who from a deed search, one could pick up who the owner of that property is. And then you could look at, the easiest would be to look at the master's website to see if that owner is in fact, perhaps, they have passed on and their estate's reported at the master's office. But one could take it a step further to try and obtain information from Home Affairs, to find out the status of that specific owner. Okay.
Ephraim is asking, will the recording be sent to our emails? Ephraim, we're not going to send it to everybody. You will need to request it from us, please, sir. Hanley, in an instance where there was no life cover on a bond, the bond was on the name of the deceased. The spouse does have an income and can pay the payments, but does not qualify for the amount of a bond. What now?
Very difficult situation where the surviving spouse may be making the repayments, but may not qualify for takeover or what we term as a Section 45 takeover or substitution of debtor. And that is purely because they've not qualified in terms of the bank's criteria for takeover. So it is a difficult situation because as an individual, you may be maintaining, but that account cannot remain on the deceased's name. And in winding up the estate, one has to remove the deceased from that account, have that account over on the surviving spouse's name so that property transfer can take place, because one cannot transfer the property with an existing bond account on the deceased name. So it's really a conundrum. It's a difficult situation for surviving spouse because, as you said, you're maintaining the monthly installments, but you just don't qualify. So very, very difficult. Some of the solutions may be, if obviously you don't have other funds to settle, the last option would be to consider selling, but it's not always that easy.
Charlotte, but I would say that that's where estate planning comes in. If you know your spouses won't be able to afford the bond, you need to plan what's going to happen if you pass on first. That is what estate planning is.
Definitely.
Next question. Hello, who do we contact to get our will done with your company and what is the costs?
Do you want to answer that, Jan?
Yeah, you can contact the office 011-748-4500 and speak to Shadre. She's our wills consultant and she will gladly assist you. And as I said, there are no costs involved. Juanita, please explain the process if there is no will but the deceased does not property but there are children. I'm not sure. Please explain the process if there is no will but the deceased does not property but there are children. Not too sure what you're asking there, Juanita. Shalosh?
Unita, probably you're asking what happens if there's no will in an estate and there's no property. I see you coming through that does not have property. There's no will. So at the end of the day, any estate where there's no will has to be administered in terms of the Intestate Succession Act. And there's a guideline in terms of what needs to be done. I'm not too sure what you're asking further, Unita.
Unita, maybe you can just pose the question again. Then there's a person, Rela Bogele, asking for a copy with his email address. Shalene or Jean, if you guys there, will you take that down, please? Gwen, the executor of my father's estate liquidated the entire estate, contrary to the will, and bypassed the trust that was to be formed. The executor found guilty of theft by general depletion. Who holds the executor account for this, for his handling of the matter?
Well, remember the body of authority that governs deceased estates is the master of the High Court. So that's your first course of action, would approach the master. Secondly, if the executor is a legal practitioner, the body that governs legal practitioners is the Legal Practice Council. So your recourse would be to approach either one of these bodies of authority and take the matter further then.
Maybe just discuss the security, bond of security that needs to be taken out.
Yeah, so if you are a legal practitioner, you are essentially covered with certain indemnities or personal liabilities. And from a practice point of view, there's also insurance that comes into play. So if any funds were misappropriated during the estate process, and potentially this is what could come into play and reimburse the beneficiaries and basically make right what the executor has done in terms of a misappropriation of funds. A bond of security is a legal requirement in terms of the estate process, and it's basically an insurance policy that is taken out to safeguard the inheritances of the beneficiaries.
Okay. Then Ephraim is asking for a recording. His email address is there on the screen. Charlene and John, please, if you guys don't mind taking that down. Okay, Jonita said does not have property. So the question is, let's just go back to Jonita's question. Please explain the process if there is no will, but the deceased does not have any property, but there are children. So there's no property in the will, and there's no property in the estate, and there's no will.
Okay. I'm assuming there's other assets in the estate.
Yeah,
so depending on the other assets, so depending on whether one is only looking at a cash estate. So if there's a cash estate that you're referring to, then one would still follow the Intestate Succession Act, and that dictates how the children must inherit or what percentages the children must inherit from the estate. But very important to note, if the children are minor children, that is, they're under the age of 18 years old, then they will not receive that inheritance in their hands. The inheritance will be paid over to the guardian's fund, and they can then claim it when they reach the age of 18. In the interim, they are, or their guardian is allowed to claim maintenance for the duration of that period, that time.
Thank you. Jonita, as ons jou nie geantwoord het nie, altyd welkom my direkte kontak. Charlene, please note there's somebody else asking for a copy. Then there's Nelson with his address. Also, Mandy is asking for that. And then Mariki. Then Nicolette. Can an estate be handled by yourselves if the deceased asked for a different company to handle the estate? The executor have not been appointed yet. In other words, there's an executor nominated, but he hasn't been appointed. Can somebody else do it personally?
So the answer is no, unless that nominated executor renounces his appointment or nomination. So if the estate, in terms of a will, you nominate Joe Soap as your executor, but you don't want him to administer the estate for whatever reason, or he's not able to administer the estate, he's still noted as the nominated executor in terms of the will. So only with his written renunciation as executor will another executor be able to approach the Master of the High Court and be appointed as executor.
Okay. Jonita has tried again. She says the deceased does not own property. There is no will. The deceased does not have minor children. What happens in such an instance? I hope this makes better sense. So that's the interstate, and then it will, yeah, okay.
Yeah, so I think it's along the lines that I explained earlier, Jonita, in terms of the Interstate Succession Act, depending on what's in the estate that needs to be administered. Obviously, one cannot administer an estate if there's nothing to administer. So it just depends what's in the estate, and if there's no will, then it's the Interstate Succession Act.
So, Jonita, what happens always is if somebody passes on without a will, the assets will be divided between the surviving spouse, if there is, and the children. If there's no spouse and no children, then we'll go up to the parents. If there aren't any parents, will come down and the siblings will inherit. That's basically, in short, what the Interstate Act is all about. Vincent, if the beneficiaries of a deceased estate have formally emigrated, how do they receive their inheritance?
One can still receive an inheritance if you have formally immigrated. It's just that different channels will be followed to get that inheritance over to you. So, for example, you can still, if it's a cash component and you formally immigrated, then the inheritance would have to, or the payment would have to go via the South African Reserve Bank to ultimately get out to you abroad. So there is a formal process that needs to be followed.
Okay. Then Domsa, I think that's what Domsa's name is asking for a copy. Can we just make a note of that, please, guys? Gwen, thanks for the answer. Further to my previous question, the executor lied about his qualifications. Also turned out that he was not a member of SAIPA and there was no bond of security as he was appointed in the will. Unfortunately, I have had no joy from Master's office in 8 years. Is there another body that can assist?
So very difficult. Was the nominated executor an attorney? I don't think. I think you mentioned he wasn't actually an attorney. Sorry, Jan, if you can just go back to that question.
Yeah. So maybe Gwen.
Yeah.
It's
Maybe
not
Gwen,
clear. Maybe
call.
There you can see on the screen there's Salochana's telephone number. Please give her a call, and then she can ask all the questions and find out what exactly you need. Guys, there's Hanley Stein that wants a recording. Sanet wants a recording. Where are we now? Madeleine wants a recording. Hans Meiberg wants a recording. Yep. Session, I will send an email with my details for copy of sites. Right. Thank you. Thank you. All right. People, there anybody that wants to ask a question and not put it on the chat box, just asks, just unmute yourself and then ask Salos, please. Otherwise, if there are no questions, then it will be the end, but let's give people a chance quickly.
Jan, if I can ask a question.
Yes, Hanley.
It's Bev.
Sorry, Bev. Sorry.
A very interesting case that I actually am busy with at the moment. I was given a property to market, and by the brother. I then got a call from the sister to say that I was not allowed to sell the property because she was the sole beneficiary. To find out that the final signatures on the actual will was fraudulent. They forged his signature to sign off the will. So what happens in a case like that? Because this is now going to court. I've been called as a witness to actually state that I got a call from her to take the property off the market.
So if I can answer that, Jan. So Bev, I think definitely you won't be able to continue, obviously, with the marketing of that property. The mere fact that the matter has now gone to court, it means that the validity of, obviously the will is being contested, and the validity of the will needs to be established now. And only once a judgment has been made around that, can one then proceed to identify whether it's a valid will or not. And then if it happens to be a valid will, then only one can say, okay, this is now the nominated and actual beneficiary to that specific property. And in your instance, if it's a special bequest to a specific person, then that person would have the authority to give you consent to market together with the executor and be able to accept any offers on that property. So until a decision is made in the court, you won't be able to do anything.
Yeah, and just to elaborate, Bev, just to elaborate on that. So if it's found that that will is not valid, then they will have a look if there's a previous will that was signed by the client, by the deceased, and if they can't find any previous wills that were signed, then we will administer it in terms of the Interstate Succession Act. Yeah, that one. I couldn't get it out. So there is a process in place, but it will have to be established first if this will that you're talking about is valid or not. Okay.
Thank you, Jan. Thank you so much.
Any other questions? Here's a question quickly from Gwen again. If the beneficiary is a trust, are the nominated trustees allowed to approve the sale of assets before the trust is formed? If the beneficiary is a trust, are the nominated trustees allowed to approve the sale of assets before the trust is formed?
So it's a twofold answer. And it would depend on whether it's an inter vivos trust. That means that if the inter vivos trust is the beneficiary to the estate, that means the inter vivos trust has been established and was in existence before death. Then the trustees of that specific trust can consent to the sale of assets. If it is a mortis causa or testamentary trust, that means a trust that's only coming into existence at the passing of the deceased person, then the trust needs to be established first, a letter of authority issued by the Master of the High Court, and then only those trustees, once they have been duly appointed, would then be able to consent to the sale of any assets.
Wonderful. Thank you, Shalosh.
Last question, can I ask?
Yes, sure.
Who may sign as a witness on a will? Can a family member sign as a witness on a will?
Hans, the quick answer is it's advisable that a family member does not sign as a witness on the will. The repercussions of having a family member sign as a witness on a will, especially if they are a beneficiary to the estate, is that they are not, the specific person as well as their spouse is not allowed to inherit more than they would have inherited if they were inheriting intestate. So a simple example would be if that witness is inheriting 75% of the estate in terms of the will, and now they're witnessing that will. If they were inheriting, if there was no will and they were only inheriting 20%, that means that is seen to be that they had unduly influenced the testator. So the quick answer is it's advisable that a family member does not witness a will.
Yeah.
Thank you.
Exactly that. We always say to clients, make sure independent person sign it, then we don't have to basically have to explain all of what Charlotte had to explain now. Any other questions, people? Thank you, Charlotte. Thank you for everybody that attended. I hope you found it informative as much as I did. May you all have a wonderful week, and then we'll chat soon.